So, hello everyone. So, today we are going to talk about the recent verdict by Karnataka High Court on hijab issue. So, in the verdict, the Karnataka High Court has noted that wearing of hijab is not an essential religious practice. It is not an essential religious practice under Article 25 of Indian Constitution. What does that mean? The essential religious practice means there are few elements in the religion which is very centric. That means that provides you the identity. If you are not explicitly doing that, your identity of being from that particular religion is violated, or let's say is not identified. For an example, offering of namaz is an essential religious practice under Article 25, which was noted by Supreme Court in Shirur mutt case. But but offering namaz in masjid is not an essential religious practice. That means this fundamental right of yours of offering namaz in masjid can be curtailed on three parameters. Number one, public order. Number two, morality. Number three, health. So during COVID 19, you have seen that on the parameter of health, going to masjid was curtailed by Supreme Court. Therefore, if hijab is not essential religious practice, it can be curtailed on certain parameter. For example, if your college and school, if your college and school has prescribed an uniform, that means you need to follow that uniform only. You cannot challenge that uniform on the factor that it is stopping you to wear the hijab, because any fundamental right is not absolute. That means you cannot challenge this, that your fundamental right under Article 19 is being violated, because it can be curtailed on few parameters, that is uniform. Now, in the judgment, the Karnataka High Court has noted the verses from Quran, the verse number 256, in which Prophet Muhammad has himself said, there should not be any compulsion in the religion in a whole. If you are making something compulsory, that is against the religious practice. So, if something is not compulsory, that means it is recommendatory. Prophet Muhammad has not used the word hijab here, but if something is not necessary, not compulsory, it is recommendatory in nature. The second part, the second issue was hijab mentioned in Quran Sharif? The answer was no. Hijab was only mentioned by the commentaries on Quran, by the scholars. The scholars who have written commentaries on Quran have mentioned the word hijab. That means hijab was nowhere mentioned in Quran. The third issue, then why hijab was prescribed? So hijab means a screen that that is for protection. So when the hijab was prescribed, when it was recommended, the social order was different. The hijab was providing a sense of protection to a woman. It provided a protection of identity. But now the social order is different. So therefore, it cannot be made compulsory to wear an hijab. So, if hijab is not essential, it can be curtailed. Understood. Now, what are the consequences? What will happen now? First of all, in the short term, this verdict would be challenged in Supreme Court. Second, we can see some decline in Muslim girl enrollment in schools and colleges. These are some things that would happen in short term. But in long term, there would be some positive consequences. For an example, it can provide an uniformity. It can provide an uniformity. Number two, any radical mindset of people. For an example, if let's say if a family is forcing a student to wear an hijab, so this thing can be curtailed now because it will change the mindset of the people. But here I would like to mention that wearing of hijab is your choice. Your choice. You can wear hijab, but not in school and college. But not in school and college where uniforms are prescribed. So for now, this is the issue. We'll meet in another video. Thank you so much.